This is Navigate Newsflash. It's a new segment that we've put together to discuss breaking news in the real estate industry. It doesn't have to be breaking news, but it is news nonetheless. I'm Ernesto.
I'm Judy.
And we've managed over $500 million in real estate transactions.
Today we are going to be discussing some new real estate laws. Every Texas legislative session produces new real estate laws, and sometimes they affect property management. This year, their 88th Texas legislature, they passed 4 new laws. Number 1, justice courts amounts. Number 2, source of funds. Number 3, evictions. And number 4, service animals.
Let's start with the first one, because this one's extremely important.
Justice courts amounts, that's fancy.
It is fancy, justice courts amounts. So let's break this down so that the viewers understand what we're talking about. There's 2 forms of court on the local level, okay? You have the justice of peace. These are the courts that are on the civil level. I can go and represent myself without an issue. I mean, you can represent yourself on any level, but it's not recommended on the county level. So let's just talk about the first level, which is the justice of peace. So anything that you may be suing someone about up to $10,000 is handled on the justice of peace level. Anything that is above and beyond $10,000 gets bumped up to the county judge. Justice of peace, which are districts, county judge, $20,000. And we're not attorneys, nor are we giving you any advice whatsoever.
None.
They're just strictly from our experiences and our observation and how we interpret these new laws, okay? Disclaimer.
Right now, if you sue someone in an eviction, you can only sue them up to $10,000 in a justice of the peace court. With this new law that was passed, you can now sue up to $20,000 in a justice of the peace court, whereas previously you would have to move that up to the next level court. Say theoretically 10 years ago, if someone was paying $2,000 in rent in your house, now they're gonna be paying, let's say $3,300 in rent in your house. So if they miss 4 months of rent 10 years ago,
that's
it's $8,000.
That's why you need a good property manager, so that you don't have 4 months worth of rent, okay? We file for eviction same month. Sometimes we can get a date the same month. Anyway, that's a whole nother segment. You want these things to be able to be handled pretty quickly. Once you start getting into that 20,000 mark, the problem is on the justice of peace level, if let's say for example, you owe me $15,000 and I win, that individual can appeal. With the appeal, I have to go to see the county judge. I'd rather have that handled under $10,000, knowing if this person's gonna actually appeal or not. Does that make sense? I don't wanna have to now wait.
To go see the county judge?
Yeah, because it's a good amount of money. If it's gonna be $15,000, I just wanna file with the county.
Got it. So you're saying you would rather, if it's 10 grand or less, take it to justice of the peace. If we're already up over 10 grand, like you're ready to go to the county.
Yeah, because then there's no appeal. What are they gonna appeal to, the Supreme Court?
That's a good point. I'm thinking more about like landlords that, let's say, grace upon grace upon grace, and all of a sudden this person owes them $15,000, but you're right. We file quickly, consistently, so we don't really see those numbers.
I'm just trying to think all things included.
That's true.
We're only applying this to landlords because there's still other civil issues for filing.
That's true.
On the justice of the peace level.
The second one is formerly called source of funds, but really it has to do with HOAs. There have been some HOAs in Texas.
Homeowner associations.
Homeowner associations in Texas.
Yeah, just so that we're on the same page, an HOA governs and manages a subdivision, a neighborhood. They have rules and bylaws and regulation, etc.
And some HOAs, one specifically, we'll tell you the story in a minute, decided to create a new bylaw that said landlords could not accept rent from the Housing Voucher Choice Program, otherwise known as Section 8. And that just muddled all kinds.
They allowed, initially, the HOA said, yes, you can do Section 8 bylaws. And then they backtracked and said, no, you can't do it anymore. Is that accurate?
Yeah.
Are there HOAs currently existing that have Section 8 voucher regulations?
Limitations, yes.
Or limitations?
Yes, there were. There are no longer.
So even if they have something that's grandfathered in, they can't do that anymore? They have to allow Section 8?
Yes.
Or it's contingent to the landlord?
It's contingent to the landlord.
Okay. If there's a property management company or a landlord that's, I don't want to accept Section 8.
Correct.
In this HOA, they still have the ability to determine if they accept vouchers or not.
Correct.
Okay.
So an individual landlord or property management company can still decide what kind of payments they will receive.
Okay. I just want to understand the application.
Sure. But what the new law says is that an HOA cannot pass one of their own bylaws that says, essentially what it's saying is you can't have individuals, families, whatever, on the housing voucher program,
Yeah.
Section 8, living here.
Listen, I'm not surprised. HOAs, stay in your lane. Why
My
are you
goodness.
dabbling and creating all these different hoops to jump through? And this is exactly why you discourage landlords. And listen, there are some homeowners who don't want a rental as their neighbor.
That's true.
That's just the reality. That's the world we live in.
We're just saying rental in general. It doesn't even matter. They just don't want somebody next to them to be someone that's renting the house.
With Section 8.
That too. In general, people get picky.
Yeah. Absolutely. For sure. Yes. And many landlords, they get burned. They suffer the consequences. Was there another one as far as fines were concerned, like limitation on fines from the HOA?
Yeah, there was some additional stuff on limitation of fines because, again, in this situation that we're going to tell you more about, they started applying astronomical fines for
$5,000 worth, no, $10,000 worth of fines for not registering their rental property.
and it was like a new registration process, totally
And in addition to
unbelievable.
that, they were sending snail mail to the P.O. box. They didn't send any notifications via email, no other ways of communicating with the landlord. And they were just accruing these fines, and they wouldn't back down.
Yeah, the heart behind this law that's been passed is that as an HOA, with that situation, with huge fines, you can't cause financial hardship to the individuals that own the houses in your HOA or that live in your HOA.
Right.
They're literally at the point where people wouldn't be able to live in their houses because they owe so many HOA fines. For what? For not filling out a form? It's not that you're not taking care of the house or you're not being respectful of the community. You didn't fill out a form.
Yeah, it's disappointing.
It's
That's
unbelievable.
terrible.
And then on the flip side, with Providence Village HOA, which is just north of us, we actually had some rental properties in this area and were intimately aware of what was happening. They hadn't previously allowed for housing choice vouchers within their community. Yeah, they weren't allowing landlords to place those residents.
Who wasn't?
The HOA.
They weren't allowing it?
They weren't allowing it. They opened it up for that to happen.
Yeah.
And then they decided, oh, we don't like how many more people are moving into the neighborhood and HUD got
Specific
involved.
race,
Yeah,
pointing
well,
out specific races.
Yeah, you can look it up. It
Yeah.
disproportionately affected females and black women.
That's sad.
Yeah, this is exactly what the Texas legislature and HUD have been passing laws to push back against, segregation within communities. And this isn't even because of like rental amount. It's literally, we don't want where your money's coming from. It's just really sad. After they said it's okay, then they said we changed our minds. We don't want that. They weren't even gonna let leases go to term at one point. It changed and changed while it was going on. And so imagine being a family in this rental home and it's, oh my goodness, are we gonna have to leave? Are we gonna get kicked out? They just crossed all kinds of
Reckless.
legal lines. The HOA now is gonna decide that they can terminate the lease. But it brought some much needed awareness to the fact that HOAs were stepping outside of their lane by deciding for a landlord who or how they could receive funds for the houses that they were renting. Big change, big deal, good change.
Number 3.
Evictions. When COVID started, and I suppose it's happened before, but we started seeing it mostly with COVID, that the county courts started requiring extra documentation, wait an extra 10, 15 days.
COVID notices.
COVID notices,
We needed to send those out.
which extended the amount of time for completing an eviction.
Yeah.
An extra 10 days. At one point, it was 20 days.
Yes.
You remember that? We were excited when it went down to 10.
Yes.
They passed a law that said they can't add any additional documents.
Yeah, and
time
this is
requirement.
listen, it gets me frustrated. We're making efforts to be better citizens, be better business people, to be able to help families that are truly struggling. Is the COVID notices was designed to give you more time if you happen to have COVID.
If you happen to have COVID.
If you happen to have COVID. It wasn't a requirement to enforce landlords to somehow, or property managers somehow educate residents on ways that they can get support. So giving you an additional 10 days. If they should have enforced that and said, hey, you need to supply them and educate them on different ways to receive help during this challenging time. Above and beyond than just saying, here's your COVID notice.
You're saying like it should have been both.
If you're gonna send a 10-day COVID notice.
Here's also some ways that you can get help during this time.
Yeah,
Yeah, that makes sense.
it does.
Like at least if you're gonna give another 10 days and there is hardship happening.
Yeah, because there's a lot of landlords out
Right.
there.
Give them some
AKA slumlords.
resources.
Oh, you don't wanna pay rent, then get out. That's what they're thinking. They're not thinking about hurting families.
Life. It happens.
Life.
It ended up being, at this point, just 10 days.
10 days. It was 21 days
21 days.
They had the restrictions first, the complete restrictions. You couldn't file for eviction. Then they had a 21-day COVID notice and a 10-day COVID notice. Essentially, no longer can they require that. It's no longer something that we have to send out.
Correct.
I mean, that's for now, because there's a spike in all of these different things that are going on. People are talking about.
Also put into effect that type of thing were going to be allowed again, it would have to first pass Texas legislature. Remember how for a while, if we did have to file eviction, we would have to make extra phone calls to say, okay, what do you guys require? And that's not the way it's supposed to be. That's why we have Texas property code. It's consistent. There's no...
There is, but the counties have freedom in the state of Texas. They have more freedom than what you will find in other states. So,
but nothing beyond property code, right?
Yeah, they can. That's why they had the restrictions.
That's what I'm saying, though.
It's not
they can
applicable.
no longer do that type of a notice because that's now part of property code.
Correct. Yes.
There are maybe other things they could do,
Yes,
but
absolutely. It's now part of the Texas property code.
correct.
The laws.
And so if we had another spike in COVID and we did need to start doing notices with ways that you can get assistance or whatever that would be, it would have to pass legislature.
Yes, and just to be clear, the Texas property code, we probably didn't share too much of the details for those who are not fully aware, is it's the bylaws for residents, tenants, and landlord relationships. What's expected from a landlord, what's expected from a resident, the expectation from the state, a mandate from the state. What's number 4?
4 is ESA, or emotional support animals. There can now be fines sent to people
Yikes.
that either lie about having an emotional support animal.
Ooh.
Yeah. Or even if they lie about this animal being ESA over and over and over again, the pet can be taken away from them.
Whoa.
Yeah.
Most of the time you find the reason that people lie is because a dog that's not allowed at a property.
True. That's not cool.
Typically, you're like, wait, your pit bulls, your emotional support?
support?
Listen, and there's nothing wrong with pit bulls. Pit bulls are great dogs, actually. They just have bad owners. But anyway, those are the common things that we'll see.
And the reason it's important is because you can register any animal you want online as an ESA, but that's not.
So how does a landlord prove that it's not real, that it's not legitimate?
Anything that's online is not legitimate.
So you need an actual physician,
Yeah.
your doctor.
You need a medical professional that's licensed in Texas to write a letter that is essentially your prescription for your ESA.
Got it. Okay.
Doesn't have to say why you need it, but this animal is needed by this individual. With that, you don't have to pay pet rent and you don't have to pay
A security deposit.
a security deposit for the pet, and there can be no breed restrictions.
I think they need to change the security deposit thing. It's still an animal that can damage the home. That's the purpose of the security deposit. There's no other situation where the government gets involved and says you can't ask for a security deposit from the resident because they're on medicine or handicap or
Right.
there's no restrictions. If a landlord requires a security deposit, they require a security deposit. So anyway, it's just interesting.
Yeah, I think the purpose behind that, though, is that if this animal is necessary for the individual to have a normal life, one of the things that we see fairly consistently are veterans that have support dogs that help with anxiety, or families that have a child who has seizures, and there are dogs that can notify you if a seizure is about to come. They don't want there to be any financial hardship, potentially, if that animal is necessary. Security deposit, that extra money, they're saying that shouldn't be a limit to where someone could live if they have to have this animal. Now, they can't force a landlord to take somebody with a pet. If you say no animals, there's no animals. Overriding point, though, that there are people that abuse.
Wait, there are people out there who abuse the system? You're kidding me.
Yeah.
No, of course.
If you need the pet, you need it.
This is really good information, Judy. Thank you so much she sent it over. Hey, we should start communicating some PowerPoints, information that's good for realtors and landlords and aspiring landlords to consume, because not many people are talking and unpacking how this applies, right? These things are just happening a lot of times on the state level or during meetings behind closed doors, and that information is not coming out. So we appreciate you guys for tuning in. Please like and subscribe. We are going to be doing the news flash more often.
The Navigate News Flash.
That's right. Again, thanks for tuning in. We will see you soon.
Bye.